this morning. Can see quite a number are still joining, so let's give them a minute or two, then we can start. Okay, so good morning once again.
Morning.
Good morning.
Okay, so we want to start our discussion today. Before we do that, I'd like to ask my colleague Charity to start us off with a word of prayer. Charity?
Yes, Nancy, I can hear you. So we can pray. Our Lord in heaven, we come before you this morning. We want to thank you very much for giving us this day, a day, Lord, that we've never seen before. And we are so grateful that, Lord, we could wake up. Thank you for the breath of life. Thank you even for giving us a good beginning. And now, Lord, we are setting up to start a meeting. We pray, Jehovah, that you be with us, God. Even as we go through the discussions that are ahead of us, we pray that you're going to be with us. We pray for our trainer. We commit him to your able hands, Jehovah, that even as we interact with us, God, you're going to give us a smooth session, Father, great insights, oh Lord, and even my Father, favor even with the gadgets that we are using. And Lord, at the end of it all, we shall remember to thank you. For this is our prayer in Jesus' name. Amen.
Amen. Amen. Thank you. Thank you, Charity. I want to welcome all of you to this webinar. It's great to see all of you. I can see we have quite a number of participants from across the country. Karibuni sana. You can go to on our chat and just indicate which circle you're from so that we can just recognize your presence. So just go ahead and do that even as we start the webinar. So thank you so much for taking your time to join us this morning and to discuss on the new Data Protection Act, which was passed into law in 2019. So we will be discussing that in the next 1.5 to 2 hours, based on how well we engage our presenters for the day. So before we do that, I'd like us to establish some ground rules. Let me share with you something here so that we're on the same page. Okay, so during our presentation, I'll ask all of you to, during the webinar, I'd ask all of you to mute your microphones. Kindly go ahead and do so that the only microphone that is on is for the person presenting. I'd also ask you to go ahead and rename your screen names so that we are able to identify you even when it comes to the Q&A. Kindly go ahead and do that. Thank you so much for those who are doing that. Chris Centers, Wanjala, I can see from Ufanisi, Karibu Sana. So let everybody rename their screen names. And then to speak, kindly, there's the raise your hand button at the top there, top of your screen. If you have a question, you can go ahead and raise your hand, and if you have any question also you can put it on the chat, and we're going to address that at towards the end of the presentation. Okay, we hope not to exit anybody who doesn't adhere to the ground rules, and we hope to have a fantastic time during this webinar. So we're ready to start. Thank you, Tony, from Kenya Police. Thank you. Karibu sana. Arthur from Keisako. Karibu sana. Thank you. Thank you. Keep renaming your screen name so that we can get to know who is here. We appreciate your presence. Okay. All right. So there's been quite a bit of discussion on the new Data Protection Act. And we thought it would be good for us for consultancy to organize a webinar so that we can deep dive on the matter. I know there've been quite a number of questions in regard to how does it affect the finance industry and also the cooperatives business. How do our staff manage data moving forward? What are the penalties for non-compliance? And to help us with that discussion today, we have the head of data governance at Cooperative Bank, and that is Tom Ruto, who will be taking us through together with his team. Tom, I'll ask you to unmute and go ahead and introduce your team and also start us on the discussion for the day. Thank you.
Okay, thank you, Nancy. Good morning, everyone. Nice to meet you all. I'm just putting my camera on. Please confirm that you can see me and hear me clearly. Nancy, you can hear me clearly and see me?
Yes, we can.
Okay.
We can.
Thank you. So before I get into the presentation, let me first introduce myself. So as Nancy has already said, my name is Tom Ruto. I'm the head of data governance and protection at Cooperative Bank. Been in data for a while, for 6 years now. But then above all, and in relation to this presentation today, I am a private citizen, and I take my privacy very seriously. With me today in the presentation, I have Rose Mwai, who's joined us. She's the head of ICT risk. She'll be listening in and hopefully touch on a few areas on risk management towards the end of the presentation. We also have Roland Otieno, who's our head of ICT security. He's not joined yet, but hopefully he'll join at the end, towards the end. Then we have Elisa Otemba, who's our legal expert, works at legal within the bank. And finally, we have Sonia Nahome, who's within the data governance and protection department. So with that and with the ground rules set, I suppose we can get into the presentation. So allow me to start. Okay, so just to let you know on what we're going to discuss today, briefly we'll talk about the data protection principles, the focus areas on data protection and privacy, then go into a bit of detail on the focus areas which concern the circles. Finally, we'll get to a checklist on what the circles need to do, what user circles need to do in order to comply with the Data Protection Act 2019. So probably before I get into more detail on the presentation, I just want to ask, a general question. What does privacy mean to individuals, and what does it mean to organizations as well? I know we've had and seen situations where probably personal data and what we're calling your privacy is infringed upon, and people react to their privacy being exposed or personal things. I'm sure most of you, if not all of you, have at one point in time, due to the COVID pandemic, where you have to work from home sometimes, and sometimes you have to come to the office. Probably you've left your phone. I'm sure most of you, if not all of you, would rather get late and go back and get your phone rather than leave it at home with whoever is at home at that time. Then, of course, we've had cases where probably you've received SMSs or even calls from unknown individuals telling you about someone who's taking a facility somewhere that they need to pay, and you're wondering how these people got your information. So these cases are widespread, and one of the biggest reasons for the enactment of the Data Protection Act 2018 is to protect against such invasions of privacy to people and citizens at large. So the Act was promulgated in 2019, as you're all aware, and Kenya was in fact the third country in East Africa to promulgate Data Protection Act. So the first country was Rwanda in East Africa, then we had Uganda, and Kenya in 2019. So before that, the Global Data Protection Regulation, General Data Protection Regulation, the GDPR, was passed, and this was a law or a regulation that covered citizens of the European Union or residents of the European Union as well. So the Data Protection Act 2019 was simply a way of institutionalizing the data privacy regulations, although we already had the Kenyan Constitution promulgated in 2010, which had an Article 31 of the Constitution that talks about the right to privacy. So this act, in effect, was making sure that that article in the Kenyan Constitution became live and it could be applied. It could be applied within the confines of the law. So some of the key definitions in this DPA, as we call it, the Data Protection Act, it defines a data subject, okay, and the data subject is you and me, our customers, our members of the circle, individuals. As long as you can identify the person that is a data subject, and you can identify people using very many elements. So if you have a person's ID number, if you have a person's location, including the IP or the geolocation of that individual, and even the biometrics, then you'd refer to that person as a data subject. Now, the law also talks about personal data, and that's why we're here today. So personal data is anything that can identify a person or information relating to that individual. And we'll see examples as we go ahead. Then it also talks about sensitive personal data. So sensitive personal data, these are things that probably because of our history as a country, and probably because of the experiences in other jurisdictions, they have been labeled as sensitive. So anything relating to a person's health, the race of that person, and for our case here in Kenya, the tribe, it refer to that as sensitive personal data. And then we have data processing, which is what you as SACCOs are involved in your effort to meet the business needs of your members and customers. You end up processing data, and basically you collect information from customers, store that information, and eventually, if you have no need for it, you will destroy it, and that is informed by the different regulations that we have. So for example, for banks, we are required to keep information for at least 7 years. And in the event probably that there's a case ongoing, then you might keep that information for longer. And then the other important part of the Data Protection Act is that it defines data protection. And this is just an assessment similar to what before you construct a house, you do an environmental impact assessment, or you'd before the government comes up with a project that involves anything in the environment, they do an assessment to see how it impacts the people of the society around that project. So the data protection impact assessment now relates to personal data. What personal data are you going to process? The impact the data subjects. So I'd already alluded to the road that we've come along in the journey of data protection and privacy. But then just to reiterate, the GDPR, like I said, applies to the citizens of the EU and residents of the EU, and it has been in effect since 2016. Okay, that's when it was promulgated, and then came into effect in 2018, 2 years later. Well, for the Data Protection Act, we did not get that luxury as Kenyans. So as soon as the law was enacted, it came into force. And what the Data Protection Commissioner and the office are doing right now is that they have general regulations that give effect to the articles in the Data Protection Act. So that has already undergone some public participation, and I think towards the end of the year, they'll be gazetted, and they will define various things. Amongst that are the fines and penalties. And I think from the Act and the general regulations, the penalty is capped at 5 million, and a percentage of the earnings of the organization. So, but the maximum that you can be fined for the Data Protection Act is 5 million. In 2020, the first data commissioner was appointed, Immaculate Kasait, Ms. Immaculate Kasait. She's been in office since that time, and we've had sessions, probably as banks, other organizations, in the course of the public participation for the draft regulations, to have and ask questions relating to how the law is going to be implemented. Key to note here is the Data Protection Commissioner does not really, and this is what you said, that the focus is not on punishing the data processors and controllers, which the law, although it defines the penalties for going against the act, our first point of concern is awareness, which we'll get into it in more detail on the next slides. So just to finalize on this slide, even before the enactment of the Data Protection Act, there were several cases that were brought before the Kenyan courts in relation to protection of personal data. And a case in 2018 when the government wanted to introduce a law that would allow them to snoop into personal conversations through the mobile phones. And the case was brought to court by a famous activist, and the court ruled in the activist's favor because of the Article 31 of the Constitution, which says that the right to privacy needs to be upheld for any Kenyan citizen. So that's it on the introduction. But before we get to the principles as well, I'd like to mention Data Protection Act. Like I said, it defines the office of the Data Commissioner, Data Protection Commissioner. It also highlights roles and responsibilities of data. Like I said, SACCOs, anyone who deals with personal data, processes that data in any way, is a data controller. So it defines the responsibilities of you as a data controller, and also processors. Processors are people who process information on behalf of the data controllers. So, for example, because we have we support SACCOs in say through their card transactions, then they would probably fall under the category of data processors when it comes to personal data for SACCO members. So those are some of the things that the law defines. But then there are also principles, and this is the basis for the enactment of the Data Protection Act. This is the basis of the enactment of that act, and it mainly focuses on three entities. So, like we said, the data subjects, those are our customers. Anyone who gives us information, their personal information, is a data subject. Then we have the data controllers, and lastly, the data processors. So the law requires that first, the data that we're given as data controllers, as SACCOs, as banks, the data that we're given is processed in accordance to the right to privacy, which, like I said, is entrenched in the Kenyan Constitution. Secondly, the data that we're given should be processed lawfully, fairly, and transparently. I'm sure most of you, when you go to buildings, public places, sometimes you're asked to provide your personal data. Okay, you're asked to give your ID number, a phone number, and probably even leave your identification document before entering a building. So in the event that that information is used, for example, to send you unsolicited SMSs, or in the unlikely event, like we've seen recently, to register you in a political party that you've never heard of or you're not a member. I'm sure all of you saw that case where people were registered under political parties that they were not really, they were not aware that they'd been registered. How do you think they got that information? So when you provide your personal data, like I said, outside public buildings, when you're transacting, I know some telcos require you to provide your identification details for good reason in case of fraud. But then when that information is used unlawfully and without any transparency, then that's against the Data Protection Act 2019. Then the other thing, the other principle is that the data that we collect, the personal data, we should collect it for a specific reason. So like I said, if we, for example, are collecting for SACCOs, if you're collecting guarantor information when someone is applying for a loan, then we cannot go ahead again as a SACCO and start using that information, for example, to cross-sell unless we had specifically sought for consent from the customer. So we cannot, for example, start sending out SMSs to the people that we have the information, telling them the SACCO is investing in, say, a new product, an insurance product that they'd like you to subscribe to. So unless that is specifically indicated to the customer at the point of onboarding or at the time of collecting the information, then that again is in breach of the Data Protection Act 2019. The other principle is that the personal data that we collect, again, as data controllers and processors, should be adequate and should be relevant and limited to the purpose that it is intended for. So again, the example where we collect member information for purposes of maintaining their accounts. So we might probably collect their ID numbers for purposes of identifying them. We might collect information about their date of birth for whatever reason. Okay? So we cannot again collect information that is unnecessary. So for example, it would be unnecessary, say, to collect information about members of the family of the customer, okay? Because that information, to the extent of maintaining the customer's account, is irrelevant and not required. And that would just open up the SACCO to a lot of disputes with the customer. The other thing is that valid explanation needs to be given any information above and beyond what the data subject is providing. So if we need family information, and I know that some of the SACCOs and societies collect information next of kin, this information you should expressly ask the customer and have them consent to you collecting that information, and as well indicate why you need that information. So if you're collecting next of kin information in the event that the customer is indisposed, then for example, whatever they have within the SACCO would go to their next of kin, and the customer needs to understand. So they need to know why you're collecting that information. Any information that we keep as well needs to be accurate. So I know when you send out the members of staff or the customer relation officers to the field to get new members, to recruit new members, or to get new customers to your SACCOs. Sometimes because of the rigorous the rigorous activity, then we end up collecting information, say, about due diligence, or I'd say a hurry, and we end up missing out some personal information or capture it inaccurately. So the principle here is that the information should be corrected, at the earliest opportunity, so that the records that you keep as a SACCO are up to date and accurate. Okay. The other thing is the law requires that we keep the information only for the period that it's required. Okay. I know that for example, we send out our CVs to prospective employers. Sometimes you collect information about prospective customers. So how long do you keep this information? And like I said, the data retention is governed by different laws. So for banks, we are required to keep it for 7 years. SACCOs, I know that SASRA has come up with regulations on how long you should keep that information. But you see, if the information is not intended for execution of a contract between you, the data subject, then that information should be deleted as soon as possible. Okay, and this also applies to online online footprints for our customers. I know that most of the SACCOs right now have portals where the customers can log in, and there's a lot of information that is stored online. So you should only keep that information for as long as it's necessary. Say, for example, if it's the customer has logged in to do a transaction, you should not keep that session's data for as long as this is necessary. Okay, so you should delete it as soon as possible. This is to reduce the risk on your part, as well as minimize any effects of a data breach to the customer. Then the last principle here is on data portability. And this relates to transfer of data outside the country. Okay, so if you, the SACCO, as a data controller or a data processor, wants to send out information outside the jurisdiction, then you should ensure that there are necessary controls to avoid that data being exposed. And like I said, the Data Protection Act 2019 not only governs the data that we have locally in Kenya here, but it also governs information relating to Kenyans that is processed outside the country. Okay, so for example, for the bank here, the card transactions that are done, we have a data processor controller agreement with the different companies that help us do that. That is information that is processed outside the country, but the law governs that information wherever it goes. So all the necessary safeguards, again, like I said, need to be in place to ensure that that information is safe from being exposed to people who are not supposed to access. So those are the principles, and I think next would go into the focus areas. These are the things that you, as SACCOs, again, like I said, as data controllers and processors, need to focus on to ensure that you're within the confines of the Data Protection Act 2019. So I think as per the last numbers that were published, I'm sure the number could be way bigger than this. The SACCOs process information of about 15 million customers and more. Okay, and this, when you think about it, when a customer comes to open an account with you, when a customer is requesting for a facility with you, when a customer is taking up an insurance product with the SACCO, they provide a lot of information that you, as the data controller and processor, have control over. You need to keep safe. Okay, so one of the weakest links that have been identified, and you know the saying, information is power. Okay, so and like I said, the data commissioner herself said that her first act is to make sure that data processors, data controllers are aware, and also the data subjects are aware of their rights within the Data Protection Act. So the weakest link is lack of awareness. Okay, I know that the trainings such as this go a long way to make sure that you're aware of your responsibilities. But as a SACCO, what you need to do is to make sure your first line of defense, these are people who handle personal data relating to customers. You have to make sure that they are aware of the data subject rights and that they are able to respond to customers' queries relating to their personal data in accordance to the law. Okay, so the other thing here, like I mentioned, is the customer data rights. Okay, so these customer data rights, they're 5 in number. I will get into more detail in the next slides. But these data subject rights are one of the biggest reasons for filing of complaints with the data commissioner. Okay, so a customer would say, for example, that they have received an unsolicited SMS from SACCO A telling them to come and take up an insurance product. And that is recorded by the data commissioner as a data breach because the customer did not consent to receiving of marketing SMSs. Okay, The other thing that the SACCOs need to focus on are their data processing activities. Okay, like we said, there are principles that guide the processing of personal data. So as long as you're within those confines, the less problems you'd have with the data commissioner. The other item is on compliance. And again, on the next slides, they'll be more elaborate. But on compliance, we have the regulations. And like I said, the law has defined the fines that come with any activity that goes against the Act. And it also defines the appointment of a data protection officer. So it recommends what a data protection officer should do and what environment they should operate in to enable them to meet the requirements of the law. Then the other bit is on risk management. These are processes and controls. How do you make sure that you have controls within the organization that minimize the risk, mitigate the risks that come along with the processing of personal data? Okay. And then lastly, and this is very important, data security. Like I said, most, if not all, of the SACCOs right now have all the activities online or on USSD, and this comes with a lot of responsibility on the part of the data controller and the data processors. As you know, to whom much is given, much is due. Okay, so if you have a customer personal data relating to customers, then you need to have the necessary security in place to ensure that that information is kept safe and it's not exposed. It's not exposed to people who are not supposed to access, and even limit cases of fraud, which I know has been a big problem for everyone in the financial sector right now. And I mean, fraud is not just in relation to money. Usually it starts with the theft of personal data. Okay, so what happens, for example, for some of the cases that I've seen is a customer's personal information is altered without their consent. So they affix someone else's mobile to the customer's account, and they're able to steal a lot of money from the organization. So, like I said, the theft starts with the cases of fraud usually start with the theft of personal data, because with the controls that are in place, as long as you're able to authenticate, okay, you're able to authenticate that this is the customer who should access the account, then I mean the SACCO has no business denying them that access. But in the case where personal data has been stolen, the identity of the customer can no longer be proven, then the SACCO is at a loss. Like I said, even for banks, it's a big problem. The financial sector is at a loss to authenticate, or at the point where they are able to tell that the data has been changed, then they've already lost data and they have lost money. So this are just some of the focus areas that we wanted to talk about on the SACCOs. And right now I want to get into more detail. Okay, and on the first part on awareness, like I said, information is power. The front-facing, the customer care service desk representatives, they are the first point of contact with the customers. Okay, so they should know how to handle personal data and make sure that that personal data is kept safe and secure. So what you need to do as a SACCO here is to come up with a communication strategy. Okay, the communication strategy needs not to be the same for everyone in the organization. So for example, for the front-facing, customer-facing staff, they need to know and they need to be aware of customer data rights, how to meet them within the organization. You already have processes that exist. So when a customer comes and requests, for example, for their statement, there's a process within the SACCO that you follow. Okay, so the front-facing customers, service staff need to be aware of what to do for the different customer data requests. Okay, then you have your what I can call the back office, where they're not really front facing, but they process a lot of customer personal data. So these are your loan officers, these are your HR, these are your people that come into contact with personal data in the course of their day-to-day activities. So you can structure your communication strategy to these different categories. And then finally, you have your the people in charge. Okay, this is the board, people in management positions. They need to be aware that they need to positively change the people and the processes to be able to meet the objectives and the principles of the Data Protection Act. Then the other thing you need to focus on is how do you let your customers know of their rights, their customer data rights. Okay, so again, this is a strategy that you'll need to put in place. So on all your customer-facing modules, say on your website, on your USSD, at any point, if at any point you're seeking for customers' consent, or you're letting them know of how you're processing that data, their data, that information needs to be very clear in a language that is easy to understand. I know you've had several lawyers saying the law is very clear, but in most cases, the law is not very clear because, I mean, to a layman like you and me, there's a lot of legal jargon inside these regulations. But for you as a data controller and a data processor, you need to put it in a language that your members can understand. Okay, don't make it ambiguous so that you get away with to try and get away with meeting the provisions of the Act. Okay, you'd be in more problems if you did that, rather than displaying this information in a way that the customer is able to consent knowingly. The other thing is the communication has to be done regularly and consistently. So you need to get it right. You need to get it right from the start. Make sure that the staff members have no two positions at one time in relation to the processing and in relation to the Data Protection Act. They should be aware of the provisions and keep up with the communication. Like I said, the public participation on the regulations was completed. Probably some of you participated in that. But as soon as those regulations are gazetted, keep up with the trends. Okay, do not end up communicating something that would have been effective 2 months ago. And you know, for this space that we're creating, data. I mean, the world is changing very fast. Something that came up yesterday is no longer relevant in today's world. Okay. Then the other thing is on tools, and this is in relation to awareness. The stakeholders need to be aware of what tools are available to them to be able to meet the standards required by the Data Protection Act. So, for example, like I said, if the customer requests for their data, the staff need to be aware of what needs to happen at what point to be able to facilitate that request. If, for example, in the unfortunate event that there's a personal data that has been exposed or breached, do they know how to handle that situation? Or if they don't have that information, they need to know that what to do so that to not make the situation worse. Okay, and the other thing is for the tools and the processes, automate at all costs. The more manual the processes are, the more likely that there'll be people will forget something or something will be left out. Okay, so if you are able to automate, and automation doesn't necessarily need to be expensive. Okay, just making sure that you say have a workflow that everyone is aware of. For example, when they're handling a data incident, then that makes your work easier. Basically, makes the SACCO concentrate on its core business other than always being in a firefighting mode. Then lastly, on awareness is on training. Again, the trainings and like the webinar we are doing right now, these are very important. Take the opportunity right now for the gazettement of the regulations to be up to date with the requirements of the law, and also how to effectively meet those provisions. Okay. So you can carry out targeted training for the different stakeholders depending on what they do and what personal data they handle. So for example, when we talk about data protection, people think that it's only related to customers. But then come to think of it, even within your organization, I'm sure, for example, your human resource department handles a lot of your personal data. Okay, so do they know how to handle personal data relating to their staff members? Okay, the standards that apply to the customers should ideally apply to you as a member of staff. Okay, so you can come up with training sessions that focus on the key data processing activities, say for the different stakeholders, like I said, for HR, for customer-facing staff, then for people in the back office who are processing customer information, guarantor information, all that. Okay, and these trainings need to involve everyone. Like I said, this compliance is not an individual task. It's a team effort. Okay, so it's not, and for your organizations, probably you're already thinking of who is best placed to handle this. But this, again, like I said, this is a team effort. As soon as you involve the other stakeholders, say like have IT, who I am sure they go through a lot of trainings because of what we said, cases of fraud. So how do they now handle personal data in relation to the Act? Then you have audit, who again come and check compliance to the set processes and controls within the organization. And again, like I mentioned, HR, they handle a lot of personal information relating to staff. They also need to be aware of the provisions of the Act, and they also need to support. For example, like I said, the law requires that you have a DPO. So how do you get the support from human resources to be able to get the necessary talent to be able to meet the Data Protection Act provisions? Then the other focus area is on customer data rights. And as you can see, they are listed there. Just a minute. Okay, so this is a breakdown of what the law has in relation to customer data rights. And the first one here is the right to be informed. Okay, so the right to be informed, and this is where consent comes in. Okay, so the customer needs to know why you're collecting their information. Of course, probably by the time you're approaching the customer has walked into your branch or your circle, they already know what they want to do. So for example, let's say I want to open an account, and then you'd give them a form to fill in. Okay, so I understand that in the course of doing business, sometimes we get very busy or we have a long queue, and we sometimes neglect to respond to all the customer questions that we get. Okay, so the customer has a lot of queries regarding what they need to fill in. Okay, sometimes you just mark it on the form and say, just fill in where I've marked. But then do you take time to tell them why you need that information? And even if you don't tell them that verbally, do your forms have a statement that tells them why that information is necessary? And do your forms have a place where they can consent and say, yes, I have understood, and I am okay with giving you this information? So, and I know most of our customers may not be able to comprehend. So this is where the awareness comes in. the staff needs to be able to explain it to them in a way that they can understand. It's an informed consent. Okay, they have the right to be informed. The right is right to access. Like I said, one of the principles and one of the provisions that come with the Act is that customers have a right to get the information and they have the information transferred to a different circle, for example, or a different jurisdiction. So they also have a right to know the kind of information that you have relating to them. So if, for example, you've collected information about of course, the customer name, their ID, identification details, you should be able to provide it to them in a way that they can review and say, yeah, this is okay, this is up to date. The event that some of the information is no longer up to date, then again, they have a right for that information to be corrected. Okay, and that's the other right that is displayed there, the right to have information corrected. So any misleading information that no longer, so for example, if the customer, you'd indicated that the customer works for Bank A, and at the time where you've given them their data and they tell you that they have since ceased being employees of that company, then it is your responsibility as the data controller to correct that information. Okay, the other right is the right to object, and this is in relation to direct marketing, and I've already alluded to it severally. So and this is one of the concerns that the Data Commissioner has raised in the previous discussions that I've attended, is customers do not want to be bombarded with marketing SMSs. Okay, so even though it's understandable that you as SACCOs have a need to expand and grow the business, you are not at any point supposed to send out unsolicited marketing SMSs without express consent from the customer. Okay, so how you might ask, so how do we expand? How do we reach out to customers on new products? Okay, so the other ways of reaching out to customers that we know, mass media, if you're sending out any targeted SMSs, you need to have an option for the customer to opt in and opt out. Okay, the customer should be able to do this themselves, and if not, the process should be very easy for the staff to be able to meet that request from the customer. Okay, so I'm sure you've seen from most telcos, since I'm sure all of us have mobiles and subscribed to some telco, you have an option. Some of them have made it very easy for you to decline all marketing SMSs. So it's as simple as dialing a certain number, and there you go. You don't have to receive any other unsolicited SMS. So this is something to think about. This is one of the biggest, like I said, the biggest concern, one of the biggest concerns for the Data Commissioner, and people are already filing complaints. So it's just that the regulations have not been gazetted, but I'm sure there'll be cases left, right, and center relating to breach of these customer data rights. Then the other right is the right to deletion, and the customer, like if, for example, you have an online platform and you no longer need the customer's information, the session information, you don't have to keep it. Okay, please delete it as soon as you're done with the session, or keep it as long as it's only required by the law. Okay, so if you're collecting information that is temporary, not related to sorry. Sorry about that. Yeah, so if at any point you're collecting information that you not necessarily need to keep for very long, again, if you are running campaigns and you've collected information from the general public, if, for example, you don't progress that information to have the customer open an account, you need to get rid of that information in a secure way that would not expose the customer again to to breaches. There's an interesting case that happened in in the European Union, where people had subscribed to a service, okay, and what happened is that information was stored, of course, on computers and whatnot, and there were hard disks that needed to be destroyed. Okay, so the organization had already transferred that information to different servers, and they now needed to get rid of the copies of that information. So of course they probably got someone else to destroy the hard disks. Information was not destroyed according to what they believed, and so you can imagine that information was exposed on the dark web, and it was up for sale. Okay, you can imagine if you have your customer card numbers, your customer date of birth, your customer names, IDs, exposed on the dark web and being sold to the highest bidder. You can imagine the kind of the kind of horror that you'd have, and especially if it relates to information sold very dear. Okay. The other right is the right to receive information in a machine readable format. And this is in relation to data portability. And like I said, they should be met within 90 days, according to the DPA. Okay, so if a customer requests for the information, please have the processes in place to be able to provide that information as required. Okay, and the DPA has templates that the customer needs to fill. So they've made it easier for you. You don't have to come up with those templates. But of course, you have to do your necessary know your customer processes to ensure that you're giving information to the right person. Okay. Then finally, the right to object to automated decisioning. And I know that most of the SACCOs right now have they have some products that they give to customers based solely on some machine learning algorithms. Okay, so machine learning is good, yes, but the customer has a right to object. So I know, for example, for the SACCO that I'm in, I can dial a certain number and can tell me how much I qualify for in a loan, for example. Okay, so if that information is reached based on an automated algorithm, then the customer has a right to object and tell you no. I mean, you probably need to talk to me before you can tell me that I'm only worth, say, 10,000 shillings, for example. Okay, so the customer has the right to object to that automated decisioning. Okay, so just some general guidelines. Like I said, the processes are important. Make sure you do know your customer processes so that you don't end up giving information to the wrong person. Okay, use the existing forms that the Data Protection Commissioner has provided in the DPA. Then record all the requests, okay, so that in case there's a dispute, then you're able to refer. Okay, you review the processes regularly and train staff on how to meet customer data rights requests. Okay, so that's it on customer data rights. Then we have the other focus area is on data processing, and these are the three that came to mind when I thought of SACCOs. I know that you process customer data to be able to maintain accounts, to be able to maintain their loans. I mean, you collect vast amounts of information, okay, relating to customers to be able to meet the contractual obligation that you have with them to run their accounts. So you can imagine if we didn't collect that information, then how would you know what belongs to what customer? So of course, the law provides for us as data controllers and processors to collect that information, to establish the relationship. Like I said, you go to the field, get customers who you think would best be with your SACCO, and you give them forms to fill. You have to maintain that relationship as soon as they're on board. Like I said, meet the contractual obligations. So how do we, for example, know that the customer has contributed an X amount to their deposits, to their savings? you need to maintain some personal data to that effect. And the law allows for you to keep that information. Okay. The other process here is on loans. I know that most of the SACCOs are into this business, and like I said, the members need, your SACCO members need this process to be very smooth. Okay. And of course, when someone is coming to you to get a facility, they usually provide as much information as you need. Okay, because as you understand, at that point they are at a point of need, and they wouldn't necessarily object to you asking for that information. But because of the Data Protection Act, you need to ensure that the customers are aware, the members are aware that this information is going to be used entirely, for example, for lending or credit scoring of the customer to know how much they qualify for. And then when it comes to the guarantors, ideally the way SACCOs lend out, they provide that information to you, and you need to make sure that the guarantors as well consent to having the information used by the member who's, for example, requesting for a facility. And in the unlikely event that the SACCO member is unable to pay, so how do you reach out to them? Okay, if they had provided alternative contacts, they need to be aware to providing that information, that you will reach out to those people in the event that you get through to them. And the guarantors are also aware that you'll reach out to them. Okay, if, for example, you need to forward that information, and this is in relation now to third-party processing, if you need to send out that information, for example, to the credit bureaus, when you advance a loan to them, how do you make sure that they are aware that the information is being processed by a third party? And it's only to the extent of keeping their credit information up to date. And as soon as, for example, they make their payments, they're up to date. And even if they're not defaulted, how do you keep that information up to date as a SACCO and with the third party? Okay, how do you ensure that the third party does not go against the provisions of the Data Protection Act? Because at the end of the day, the data commissioner, when they land at your SACCO and because of a breach by a third party, then you'll be in trouble. Like I said, the law defines a penalty of up to 5 million shillings. So you can imagine if you have 500 customers complaining, and if in the event that they take up that case, then you'll be required to pay that much money. Okay, so these are the areas of focus, and I think for SACCOs, those who are on the webinar, then you need to be able to streamline these processes. Okay, streamline these processes, have consent from customers at every point. If you are introducing a new product, have the customer consent. If you're sending out a marketing SMS, make sure that they have opted in. And the commissioner said that lack of a consent does not mean they've consented. Okay, so by default, it does not mean that since they have not said they're okay with receiving the marketing SMSs. So this is a big shift. Make sure as soon as possible you're able to reach out to the customer's end. They consent to receiving that marketing information relating to, like I said, any new products that you come up with, or general information that you'd like to share with them. As much as possible, make sure that the customer is able to handle that consent themselves. Okay? They're able to log into a portal, and they have the opportunity to see their data, correct it. They have the capability to amend, and they have a capability, for example, to opt in and opt out of data, of the processing of their personal data. Okay. The other part we have is on compliance, and this is in relation to data breach incidences. So within the bank ourselves, we come up with a process to ensure that if in case personal data is exposed, we are able to meet the requirements of the DPA, which, as required by law, you're supposed to, in the event that personal data is lost or exposed, you're supposed to report to the Data Commissioner within 72 hours. Okay, so there's a form that the Data Protection Commissioner has put up on their website. So you're able to go in and fill in the the form. Okay, but the 4 steps that we thought were necessary for us, and I am sure applies to you as well, is the first thing to do is to notify. Like I said, for example, you become aware that some personal data relating to 5 of your customers was inadvertently exposed, say because one of your staff members left their laptop unlocked or their desktop on, then you need to notify the Data Commissioner. You also need to notify the people who are affected, the data subjects. Okay, and the law says that you need to do that in writing, okay, within a reasonable time. So of course, you'll have to do an investigation, get to understand, okay, so what information was lost. And then if you're a data processor, you need to notify the controller. So for example, if in the course of doing business with the SACCOs, Cooperative Bank realizes that some card information was exposed, we need to get to the SACCO involved and notify you of the nature of the breach, and if we are able to tell how many of your customers have been affected. Okay, the other step is to investigate the nature of the breach again, the cause, what led to the breach, and if you're able to identify the person who accessed that information without the necessary authorization, then you need to know so that you can take steps to remediate. Okay, so that's the third action you need to do. You need to make sure that that situation does not occur again, and even reach out to the customer, like I said, to the members. So for example, if the 5 or one of your customers had shared their password, their account password with someone, I mean, when you reach out to them, you need to tell them of the measures they need to take. So please change your passwords. I'm sure you'd seen, for those who are on Twitter, communication a while back from Twitter asking the members to change their passwords. So that was informed by a data breach that occurred, and people's passwords were exposed. More than 900 million records were exposed. So even though they were able to stop the breach, they still informed the customers or the members, just as an extra step, as an extra measure, to ask them to change their passwords. So this is something that you can do. For the people who are affected, reach out to them, ask them to take the necessary steps to avoid losing their data or their money. Then lastly, you need to document. Okay, documentation, like I said, is very important. You cannot overstate that you need to document, because, like I said, some of these cases will end up in court. Some of these cases will be taken up by the Data Commissioner. So you need to indicate that whatever action you take, you need to indicate it in a very clear way, so that any person referring to the same case will be able to see the facts and see the mitigation and the remediation actions that you've taken to ensure that the breach does not occur again. Okay, so these are the 4 steps. You don't have to memorize them, but well, you need to ensure that we have processes in place, because, like I said, there are cases that have already been reported to the Data Commissioner, and I'm sure most of them are with the financial industry players. So eventually they will get to us. The Data Commissioner has the authority under the Act to carry out audits. Okay, and they can do that with the help of third parties. So they'll eventually get to it. Okay, and if you don't have a record and they have a case that has been lodged with them of a complaint, then I'm sure it would be way worse for you. But at least if you have taken steps, documented and reported, and then I mean, if there's no loss, or if the customer does not intend to take it further, then you take up steps to ensure that the breach does not occur again. Then still on compliance, like I said, the Act recommends the appointment of a data protection officer. Okay, I'm sure some of you in the session are already thinking of whether they fit to be a DPO. Sounds very nice, but well, there are responsibilities that come with it. Okay, so although the DPO might be a staff member carrying other duties, the law recommends that this office should be independent. Okay, should be independent and be able to carry out oversight on data processing activities. Okay, so of course the qualifications are listed, relevant academic professional qualifications. So if you're someone who's handled personal data for a while and you are aware of the regulations that are in place to control that, and you have, like I said, relevant is a matter of discussion. So are people confident in your technical skills and knowledge relating to data protection? Okay, so if they're confident in your knowledge and your skills, then most likely you fit to be a data protection officer. But the roles, like I said, the role sounds very nice, but your responsibilities under the Act, one is to advise the controller and processors and the employees on the Data Protection Act requirements. Okay, so you need to know your staff. For the data protection officer, they need to be able to ensure compliance to the Act as well. Okay, they need to capacity build their fellow employees and then cooperate with the Data Protection Commissioner. So the Data Protection Commissioner requires that the DPO's contact details are published somewhere where staff and members of public can be able to access, okay, and see. So they can get in touch. I mean, you'll get calls, you'll get emails from members of from your members relating to provisions of the Act, and they should be able to reach out to you easily. Okay. Then, like I said, the recommended practice is that the DPO should be an independent person. Okay, regular reports to the board. Okay, so this can be done through, like I said, depending on the organization setup. You can have this through audit. You can have this through compliance. If you have people dealing with the risk, so regular updates to management need to be done, so that other than getting the buy-in from them, they are aware that you're implementing the data privacy protection roadmap. Then, like I said, compliance is not an individual responsibility. So the DPO, even though is one individual, there has to be collaboration with the control functions. So the control functions are, like I said, audit. So audit are the ones who will help the DPO to tell if, be able to analyze and tell if there's a breach of the controls that have been set within the organization, and then how do they mitigate the risks, and how do they strengthen the controls. So this again, like I said, it's a recommendation by the Act. You can be a data protection officer as a role, but then you can have a different role, be the DPO designate. So you can still be able to do other functions as long as they're not in conflict with the provisions of the Act. Okay. So I think at the beginning I had introduced Rose. She will pick up the questions that come with the risk management, but I'll take you through the slides. So on risk management, we have the component bit. Okay. So for risk, and you all know risk is about the controls, processes and controls. Okay. So you need to define a privacy strategy for your SACCO. Okay, come up with priorities, things that you want to do now, things that you want to do in the midterm, and things that you want to do in the long run. Okay, then you need to define the policies and procedures and a framework to work within. Okay, then ensure that you're able to process customer or personal data in a safe manner. Okay, when you talk about risk managers, these are people who are risk averse. Okay, so it's good to have that component within your data protection and privacy strategy to ensure that you've thought of the risks that come with handling personal data. So this is where the data protection impact assessment comes as well. So the data protection impact assessment relates to you defining the personal data that you're collecting from customers and what you're going to do with that information and the risks that come with it. So for example, if you're collecting information relating to customers' health, I mean, how do you ensure that only the necessary people have access to it? Okay, so manage the risk, manage the third-party data privacy risks, have the necessary documentation. As a data controller, SACCOs as a data controller have the right, and you can set these up within the contracts that you have. You have the right to monitor the activities of the data processor. So for example, if the bank is processing some data on your behalf, you have the right to be aware of how we are doing it. Okay, and if you feel that it's not being done or it's exposing you to more risk, then you have the right to demand that those practices are changed. And in the event that they're not able to do that, then you're free to seek out other data processors who are able to meet your requirements. Okay, then we have the incident management. I think I'd already taken you through this, the requirements of the law. You have the risk. So what's the exposure? So if personal data has been exposed to third parties or people who are not supposed to see that, what is the risk? Okay, the risk can be reputational, can be financial risk. So we already have the financial risk defined, 5 million shillings. But I doubt there's an easy way to quantify a reputational risk. Okay, you can imagine the SACCO that you work for currently. How much is your reputation worth? If, for example, it came out that SACCO A has their customers' information on the internet, I'm sure you'd be out of business in a few days. Okay, so how are you able to mitigate such? Okay, then again, like I said, processes and controls. Implement a data lifecycle management. Data lifecycle relates to the collection, storage, and eventual deletion or destruction of that information. So how are you able to control all those steps within the data lifecycle? How do you tell which information you need to keep and for how long? And how do you tell which information you need to get rid of? And if you're not getting rid of that information, how do you get rid of the personal data that is within that set of information? And then, as we'd already said, prepare to respond to the data subject's queries. Still on risk management. Okay, so these are the steps, again, in relation to risk management, data privacy. So there's the planning bit. Then you need to implement, review, and then continuous improvement. Like I said, the data privacy space is changing at a whatever was relevant a month ago is no longer relevant. And the innovation that comes within this space, there's a lot of risk relating to processing of personal data. But then, so you need to come up with KPIs. Like I said, audit, risk, they really work well with KPIs. So how have you met the KPIs that you've set out? And have you assigned them to the relevant stakeholders? So carry out audits. This is assessments that you can do internally. I know that all of you have an audit function. So how do you integrate the audit bit the data privacy and protection bit. Okay. Then there's the data inventory and analysis. This is more of a data mapping exercise. So how do you tell what information you hold for customers and where it is? Okay. So you need to do a data exercise. Start from the most common process, which, for example, is a customer onboarding process. So map out what personal data you collect at that point and where it ends up. Okay, how many people touch that data before it gets into the system, and after storage, who has access to it? And this again relates to the systems that you have in place. I am sure that there are rights management within the systems, controls, make sure that only the necessary have access to personal information. So enforce those controls, have reviews frequently, gap assessments, report on the status, and create a remediation plan for the gaps that you've identified. Okay. Then the other bit is the institutionalized data protection and privacy. we cannot again overstate the importance of this. You need to get buy-in, again, like I said, from the board, from top management, on the importance of data privacy. Okay. I know that for GDPR, they've been able to quantify and say that one element of personal data costs around $146. Okay, so for when you're pitching this agenda to the board or top management, they usually tend to listen when you involve money. Okay, so if you tell them the risk that comes with the exposure of personal data in monetary terms, you're more likely to get the buy-in. And it's not overstating. I think we've seen, and there are documented cases. I think the largest fine that has ever been been apportioned is $800 million. Okay, and this was under the European Union again. $800 million is a lot of money. So in the event that all your customer data is exposed, like I said, with the figure that we've apportioned, $146 per personal data item. So per customer, you have like 10. Okay, so multiply that times the number of customers that you have. You can see the exposure that the SACCO has. Okay, so that's on the risk management. Then on data security, again, this, and I think back when I was in consulting, I got to work with several SACCOs on this. And I mean, cases of unauthorized access to systems are widespread. And it's not just for SACCOs alone, but I mean, everywhere you think about anyone touching personal data. And like I said, cases of fraud usually start with the theft of personal data. So how do you mitigate? How do you ensure that you don't lose personal data and eventually lose money? The first thing is on encryption. Okay, so is the data that you hold encrypted? Okay, even though the data is accessible on the front end for the systems that you use, in the event that that machine is not locked, or someone is able to have a backend access, are they able to tell what data is there and who it relates to? Okay, and like I said, the Data Protection Act only focuses on personal data. So if, for example, someone accessed your SACCO information and the information is encrypted, you have no obligation under the Data Protection Act. If I accessed information about customers of a SACCO, even if there were 10 million records, and I'm not able to tell to who that information belongs, you have no obligation, and you won't face any sanctions from the Data Commission. So encrypting information, anonymizing that information is very important. The other thing is on security measures. So whenever you have a new system coming on board, and we already spoke about data protection impact assessments. So you have the first bit where you need to do an impact assessment on the personal data that you're collecting and you'll be processing. But then the other bit you need to do is to test the systems thoroughly. Excuse me, thoroughly, to ensure that the systems are secure enough to hold personal data. Okay, so and there are many organizations that can help you do this. Help test out the vulnerabilities of the system. Okay, is someone able to, for example, brute force and pick out passwords from the system? Are they able to access personal data that is not supposed to be stored? Again, when new systems come on board, sometimes these things are not taken into consideration. But as a SACCO in this era of data privacy and the DPA, you need to have thoroughly done the tests on any new system, on the existing ones, to read them of the vulnerabilities. Then we have the other bit is the secure data inventories. Okay, so like I said, if you don't need to keep that information for as long as you've kept it now, please get rid of it. If the customer has since closed their accounts, and according to the regulations, probably, like I said, for banks, it's 7 years. If it's beyond the 7 years, get rid of that information. You don't need to keep it, because it exposes you to financial, like I said, risks, reputational risks in the event that it is exposed. Then the access, the role matrix, again, need basis. So if you have customer information relating to loans, if someone in HR needs not to know about members' loans, for example, minimize that access, okay, and have controls in place to ensure that anyone who has access, you're able to tell. You have logs in place and reports to ensure that you're able to tell who accessed what and when. Okay, so this, again, in case you notice an unauthorized access, then you can easily shut down and do the necessary to ensure that it stops and secure the system. So that's all on the focus areas. And I know that I've spoken for long, and we've probably gotten some, not gotten some, but all is not lost. I think I came up with these last slides so that for people like myself who probably get to be attentive when we hear that the meeting is about to end, so that in case you forget everything else that we've talked about today, these are the most important slides that you need to remember. Okay, so this is a simple checklist, what you need to do to ensure that you're within the confines of the law. And this is what we've already started implementing as an organization ourselves, but you as a SACCO need to come up with ways of doing it. And you can put this on a whiteboard somewhere and check it off as soon as you're done with it. Okay. So on the people's checklist, we have the communication bit. Like you said, come up with a communication strategy. This is one of the webinar that we're having today is one of the things that you can do. You can have training sessions with your staff to communicate the provisions of the DPA. The other thing that you can do is to set up a data protection committee. A data protection committee needs to have the relevant stakeholders. So you can have your audit there. You can have your IT there. You can have your security if you have, representation from key departments to clarify decisions relating to data privacy and protection. So with the DPO there, the DPO cannot purport to make decisions as an individual. Okay, so what gives him the power to do or to come up with strategies and implement? So the data protection committee is very important. You can set up meetings monthly or bi-week, twice every 1 month, depending on where you are at in the implementation of your data privacy strategy. Okay, so of course the other thing that you need to do is to appoint a DPO, and we've already talked about what the DPO will do and what needs to be in place for him or her to operate effectively. Okay, so the other thing is involve the control functions. We've already talked about audit, set up KPIs for your team, for your organization, and I mean, check them off. Make sure that you have someone to review and tell you whether you're doing it right. Okay, so you can do the internal audits, and once in a while, external audits, and also the data commissioner has been given the right to carry out these audits, so they can land at your office anytime and demand to see what you have done in relation to data privacy and protection. Then the other thing on the people checklist is the change management. Come up with a way to get the goodwill and the buy-in from the organization, because like I said, the data protection roadmap and the implementation of that, it's a lengthy exercise. It's a lengthy exercise, and at times probably people might feel that they're tired, but then make sure to have an effective change management in place to ensure that you don't lose focus. And once you have done it, again, all that you'll have to do is to keep reviewing to ensure that it is within the provisions of the Act. Okay, so that's the people checklist. Then we have the document checklist. We have a very nice briefcase here with all the necessary documentation. These are not all the documentation that you'll need to do, but these are the most relevant. First is you update your general terms and conditions. Okay? The general terms and conditions are statements that are available on the internet or your website, highlighting what your organization is doing in relation to data protection. Okay, so you can display on your website what personal data you collect and how you process that information. And of course, the contacts, like we said, the DPO's contacts should be there, just in case the customers or the data subjects have any questions. The other one is the data privacy statement. I'm sure you've seen this, and and for most of these statements, you don't have to reinvent the wheel. Okay, there are many organizations that have already implemented this. There's nothing wrong in borrowing some of that knowledge. Have a look at the big organizations that have implemented or have started implementing data protection. You'll get privacy statements, and even for the social media platforms that we have access to, I'm sure you've seen notifications severally with the privacy statement update telling you about GDPR, all that. So you need to come up with a data privacy statement, which is a general statement on how members' data is, the customer's data is processed. Okay, and again, this should be accessible to everyone. Okay, everyone should be able to see that. Then we have the data protection and privacy policy. So again, when you talked about the controls, the KPIs, and the awareness, so what guides the members of staff on handling of personal data? So the data protection and privacy policy is what defines what you need to do and how you handle personal data, and this is just for internal use. Then, if need be, you can have a data retention policy or integrate it with the data protection and privacy policy. So the data retention policy defines what information you keep and for how long. Okay, for how long we need to keep that information. We have the data classification policy. Again, like I said, depending on what personal data we are collecting, and you remember that we have sensitive data. So if you have things like health records, biometrics, sensitive data, of course, you need to be able to classify what information you have. Okay, so classifying that information ensures that you're able to label it and protect it by applying specific policies. So for example, if you manage to get a tool to do this classification for you, and I know some are being implemented by the different companies, then for example, if something is highly sensitive or it has personal data, the person handling that information needs to be aware that this is personal data they're handling, and therefore, if for example they are to destroy it, they need to make sure that they shred. They don't just leave it open for people to access. Then the other one is a data processing agreements. Like I said, SACCOs work with third parties like banks every time, but you need to come up with the data processing agreements, data sharing agreements with the people that you work with, the organizations that you work with, to regulate how they use the information you give them. Okay, and make sure that in the event they don't meet your requirements, then you have a legal recourse and you're able to to take action. So that's on the documents. Again, like I said, these are not all, but these are what you can start with. We have a process checklist again. Okay, so the first checklist the first process that you need to set up, if you don't have that already, is a process to meet the customer data requests. Okay, like we said, the customer has some data rights. Okay, so they have the right to have the information in a portable format. They have a right for the information to be corrected. They have a right to information. So do you have processes in place to meet all those requests? Okay, so those customer data right processes you need to set up. And if you already have them, you need to enhance them to meet the Data Protection Act requirements. The other one is a data mapping process. Like I said, you need to know what information you have within the organization, where it's stored, who touches that information, basically how do you access it. Okay, so that's key. And then the other one is a data classification process. Okay, and this is very important, especially for reporting of data breaches to the commissioner. So how do you tell the commissioner that, well, even though we lost some personal data, luckily for us, we had encrypted it, okay? Or we lost personal data relating to customers' mobile phones, and that's all that the person who breached the system has. So the data classification process will help you to identify what type of data you have, and in the event that you lose it, the impact that it would have. Okay. Then set up an incident management process, again, in relation to the classification. The incident management is what the law requires, that you report all breaches to the commissioner within 72 hours. So you have to set up a process in place to ensure that you're always within the requirements of the law. And then lastly, this you can do over time, is you need to implement a privacy by design. And privacy by design is where you minimize the amount of personal information that you've exposed. Okay, so for example, if you're able to anonymize the data, and this is often done in research where you provide information to someone collecting data, but they don't keep your personal information, they don't keep your name, they don't keep your your ID number, for example. They only keep, say, a subject number. Okay, and even if someone accessed that subject number, you won't be able to tell that you're the one who gave that information. So that's privacy by design. On all your systems, make sure that again, customers are able to opt in, opt out of processes that you have, as long as they are not directly impacting the contract that you have with the customer. So I think that's it for the checklist. And again, we'll share the slides with you so you can have a look at the checklist whenever you've started implementing the strategy. And you make sure you're within where all the other organizations are in relation to giving effect to the Data Protection Act 2019. So that's it from me. Thank you so much for listening to me. I hope I didn't lose you along the way. And I'll now welcome questions, and I think Nancy will moderate the session. So I haven't had a chance to look at the chat, but Nancy can pick it up. Yeah, thank you.
Thank you so much, Tom. Thank you for the new knowledge and insights on data protection and privacy. We really appreciate the presentation. So it's a very rich presentation. I can see quite a number joined us in the middle of the conversation. You have been listening to Tom Ruto, who is the Head of Data Governance and Protection at Cooperative Bank. and I'm moderating the session. I'm the head of training at COP Consultancy. So karibuni sana. We'll go straight to the questions. And Tom, maybe you'll guide us who on your team will respond to the questions. But the first question we have is, I'll read it as it is. What's your take on the information that security guards collect at entrance to buildings, including visitors' IDs, full names, and mobile numbers? Sometimes one has to present the actual ID or they are denied entry into the building. Maybe let me read out another question, then you can answer at least two at a go. The other question is on what's the role, no, this was a comment that the DPO role should be handled by audit stroke risk department for SMEs. Maybe you can comment on who is best placed to handle that role.
Thank you, Nancy. I think I don't know if Rose is still on the call, and I don't know if Roland has joined. But anyway, so I'll take the first one on providing your personal information to the security guards. I mean, like I said, when I started, I'm a private citizen. I rarely give out that information, and I'm sure some of you have come up with ways to mitigate. So sometimes when you ask for your ID, you capture the wrong ID number, you change a digit or two. And I've had people say that as soon as you transact or give your information at a building somewhere, within 2 days you get random calls or SMSs. So you probably, to that extent, you're not able to minimize, especially for where they ask you to leave the ID with them. But better safe than sorry. If it's a matter of proving that you're in that building, I suppose most of them have CCTV cameras now, so you can be able to prove that you are there. But if you can leave out the personal information, then the better for you. Okay, in terms of the unsolicited calls and SMSs that you'll get. Okay, so if it's a requirement, of course you'll give out the document. But if not, I mean, for me, this is a personal opinion. Change a digit or two for home ID number when I'm giving out that information. If it's a government entity, you need to provide the correct information. And one of the provisions of the Act is that personal data relating to requirements of government, they need to be met. There are no restrictions to what government can ask for relating to your personal data. So if Rose is still on the call, you can respond to the question on to the comment. You can respond to the comment on having audit taking the DPO role.
I hope you can hear me.
Yes, Rose, we can.
Okay, let me put on my camera. As I will attempt to respond to that question. We actually had a similar question during our KBA meeting as the different bank representatives. And it was a debate between compliance, whether it's a new function that should be created or it should fall actually under ICT under CIO's office. That would be the head of technology. My personal opinion is since it's a shared function, there are different aspects to the requirement. So you can have one person who is responsible for implementation and then have different people from the different functions holding or acting on the requirements. Because, for example, there's a risk aspect, which Tom has clearly articulated, and then there's the data protection aspect, which will also be covered by someone from information security. There's a review aspect, which will be done by either an internal auditor or an external auditor. And then there's also the strategy, who will lead that strategy. So for me, I see identify an individual and then have a cross-functional support sort of team to do it. I hope I have attempted to respond to the question.
Indeed, Rose, thank you. Back to you, Nancy.
Rose, Rose, maybe you could also respond to a question from Gabriel on whether is there an opportunity to outsource the role of a DPO.
Thank you, Nancy. Looking at the amount of internal alignment that needs to go into place, I would think as a start off, you need to have an internal person who can be guided by or supported by an external party. But we need to have someone who owns it in the organization. Maybe Tom can add on to that as you look at the guidelines of the Act.
Thank you, Rose. I think when I started off, I said when people say the law is very clear. Luckily for us, we have Elisa. Elisa is on the call. Like I said, she's a legal expert. She can tell us what the law clearly states. Again, when you say the law is very clear on the DPO. Elisa, if you can hear us, you can comment on that. And the question is whether you can outsource the DPO role. Elisa, can you hear us? Okay, probably she'll jump in. But yes, I think as Rose is saying, the law requires that you appoint a DPO or a designate. And for me, the law, I think the way I've interpreted it is that it should be a member of staff. So, of course, you can get the support from external entities who can do the audits, the assessments, but then the DPO needs to be within the organization. We also have Roland on the call, so if there are any security questions, Nancy, Roland will be glad to respond to that, but please proceed.
Okay, other question that we have, Caroline, I've seen your hand. Let's take this other question, then we'll come to you. So there's a question, Tom, on is there a risk sharing members' contact with staff to contact them?
Okay, Roland, do you want to take that one?
Thank you. Please repeat the question, Nancy. A risk?
Is there a risk of sharing members' contacts for staff to contact the members?
Thank you for that. By members, you mean members of staff or clients?
No, so members within a cooperative setting who are their customers. So where they share the details with other staff to contact the members, the customers, yeah.
Of course, there is a risk because the moment that that contact information is shared with staff members, it could be misused. What I feel is important in this particular case is to keep a catalog of who has been given that access to that information, so that in the event that something unsavory occurs, we know who has had access to that information. We have an inventory of it.
Okay, thank you. The other question we have, Tom, how long should you perform a data impact assessment according to Data Protection Act?
Okay, I think I'll take that one. So the Data Protection Impact Assessment should be done before, say, a new project or a process that involves personal data is carried out. Okay, so at any point when there's a change in that process, or you have increased or you have changes to personal data that you're processing, then you need to do a data protection impact assessment. And like I said, there's a template provided by the Data Protection Commissioner on how to carry out the DPI. So this one is very straightforward. Anything that involves personal data, do an impact assessment first before you proceed.
Okay, thank you. Now we'll go to Caroline. You'd raise your hand, Caroline Akinyi. You can go ahead and unmute and ask your question. Caroline? Okay, I think we've lost Caroline, but please go ahead and share any other questions that you may have on the chat, and we'll be glad to respond to them. I don't think we have any other pending question. If you have a question, you can go ahead, you can raise your hand and unmute and ask your question. Okay. Let me see. There's a question from Robert Kirui. One of the data shared widely without owner's consent is phone numbers. Please comment on that. Tom, you want to take that?
Yes, thank you, Nancy. So, Robert, like I said, mobile numbers is it's personal data, and the DPA clearly outlines that. And even for the GDPR, one of the biggest fines that has ever been put to a data controller was in relation to customers who got unsolicited calls from the organization, marketing calls, and they were fined heavily on that. So for mobile numbers, and there's several laws, even besides the Data Protection Act, that talk about misuse of that information, and customers have clearly complained getting unsolicited calls and SMSs. So I'm sure the Data Commissioner is going to weigh heavily on such, and for SACCOs, I mean, you need to keep that information, guard it as much as possible. And don't let it out to third parties without the necessary controls in place. And even you as an individual, don't just go filling out your personal information, mobile numbers everywhere. So like I said, the only entity that is allowed to do that without restriction, of course, is government. And I'd alluded to the case that was brought before the courts in 2018. And the government wanted to snoop on calls, so in relating to mobile numbers and all that. And it was ruled that they couldn't do that because of the right to data privacy. So phone numbers are part of the personal data. Like I said, without the necessary controls, this shouldn't be shared.
Okay. Thank you, Tom. The other question we have, and maybe Roland, you can respond to this. It's in relation to sharing borrowers' information with their guarantors in case they need to contact them. So maybe you can respond to that on how they should go about that.
Nancy, sorry, probably before Roland responds to that, I think Roland would respond to this question that came after that one. Probably Rose can handle the bit on the guarantors.
Okay, that's fine. Okay, so maybe Rose, go ahead, then Roland.
According to the Act, when you're collecting the customer's information, of course, there are the consent, the terms of reference that you indicate on the contract that we will get in touch with ADCP just to do some KYC checks So in regard to on sharing borrowers' information with their guarantors, I think it forms part of your KYC and also part of your normal work as you're providing the facility. So if you've clearly articulated it in your terms of reference, then I don't see a non-compliance in that regard.
Okay. Okay, thank you. Thank you, Rose. Roland, you can take the next question.
Yes, thank you. For the guys who have not read the question yet, the question reads, is the Act clear on the data that SACCO normally share with software vendors for integration, in brackets, third parties? Yes, the Act is very clear. And in the event that a SACCO is going to share information with third parties, first of all, the customer must be notified and they must consent. In the event that data has been shared with a third party and something unsavory occurs, like say, for instance, the unsolicited calls that Ruto had mentioned earlier, then the SACCO will be liable for that.
Okay, okay, thank you. Thank you, Roland. I don't think we have any other question. I don't know if Caroline Akinyi is back on. She had raised her hand at some point. Caroline? Okay, so let's go to Edith's question. In case of recovery from guarantors, which documents can we give the guarantors for legal follow-up? That would be for Rose or Tom?
Yes, probably just before Rose comments. So this, I guess this will be one of the biggest challenges for the SACCOs, because even though the guarantors are members of the SACCO, they probably the consent process for them needs to be set from the beginning. So I don't know how the different SACCOs do it, but for the one where I'm a member, they will send out a notification to the person I'm seeking to guarantee my facility and tell them that so and so has given your name and contact as a guarantor. Please indicate the amount and if you accept to be a guarantor. So probably that process needs to be enhanced a bit. The guarantor needs to know their rights and the responsibilities that come with that guaranteeship. I mean, if I know that they already know, members already know that in case the person who guaranteed fails to pay, then probably the deposits of the guarantors would clear the balance. But this needs to be documented. This needs to be documented. And say when you're sending out the notification on SMS or on email, you can put a link that points out to their rights as a guarantor in relation to the DPA, so that when they're giving the consent, it is informed, and we don't eventually go against the provisions of the Act. Say in case the SACCO decides that other than sending the defaulter's name to the CRB and the contacts, we can also send the guarantors just to encourage them to pay, then I mean, of course, that's against the law, because the guarantors have not been informed of that. So they need to make an informed consent. They need to give an informed consent. And again, I mean, SACCOs are respectable organizations. So I doubt that they would want to operate like the various organizations we've seen that harass customers and misuse personal data. So of course you have such things to consider when you're dealing with the guarantors as well.
Okay, thank you, Tom. Thank you, Tom. Edith, I hope we've responded well to your question. We don't have any other questions. Maybe I'd like to reiterate that if you have not registered for this webinar, go ahead. We've shared with you the link on the chat. Go ahead and register so that we are able to share with you the notes and also the presentation. The other thing I'd like to mention is that at COP Consultancy, we have received quite a number of requests from SACCOs and individuals who would like to be taken, would like their teams to be taken through this training. So we are ready and willing to do that for your team at a reasonable cost. So get in touch with us. We're going to share our email address and contact on the chat so that you're able to get that information and send in your requests. The other thing we can also do for you at Core Consultancy is the data classification policy. I think Tom mentioned that in his presentation. We can help you come up with that policy, draft it accordingly so that you're compliant, okay? I think, Charity, you've raised your hand. Yeah. Kindly unmute.
All right, sorry, I'm saying, I was looking at the question from Edith, and when the grantors have already been recovered money by the SACCO, they normally sometimes require the SACCO to give them evidence that they paid money for the defaulter so that they can follow up maybe with the cooperatives tribunal or take legal action against the defaulter. So I don't know if what Edith meant, that if we are giving information to the guarantors concerning a loan they already paid, whether that is okay and what information we should give to them. It's the question of the question. Thank you, Nancy.
So Tom, maybe you can add on to that. So what Charity is asking is what information should be given to guarantors?
Okay. I think all in all, when the customer is requesting for the facility, first of all, they need to know what information we are collecting and what information we might eventually share with the guarantors and any other third party. Okay, so like I said, information, consent, informed consent is very important. So if we are told the customer or the member that we're going to share your name, your phone, the loan amount, and your postal address with the guarantors in the event you fail to pay, then they need to see that in the document that they're signing. Okay, and so that when in the event that you give that the guarantors that information, they cannot then go again and complain or report that as a breach of their personal data. So if you need to add to that information that you're providing the guarantors with, then you need to amend as required any documentation that the customer or the member signs, and so that they make an informed decision on whether they want to proceed or not.
Okay. Okay. Thank you, Tom. I don't think we have any other question. Does anyone else have a question? You can raise your hand or post it in the chat so that we close in the next 2 minutes.
Okay, this is Stephen. I have a question. Huh? I don't know whether you can hear me.
Stephen, which SACCO are you from?
Safaricom SACCO.
Yes.
Yeah, you've talked about the amendment of the document, and this now seems to be for new cases which are coming up. Huh? How do we deal with the cases whereby by the time maybe the loans was given out to the member and the right, that form did not capture such details? How do we go about those now the past cases, because now the form can only be amended maybe from now and in future? Thank you.
Okay, thanks, Stephen. I think what's important here is to take the earliest opportunity to amend the forms first. But then, of course, you cannot apply the provisions of the Act in retrospect. Okay, so if you're not able to, and I know the way the SACCOs operate, a customer would come for a top-up of the facility. You take the opportunity to tell them of the updates. And as well, we talked about displaying the general terms and conditions on your website and pointing the customers in that direction, so that they are aware that for any new facility, then those regulations are going to apply. But then for the existing ones, please limit yourself to the consent the customer gave for existing ones. I mean, in the event that the guarantors need to take up the case with the tribunal, the courts, they need to know that they are limited because of the existing contract that you have with the customer. But at any opportunity that you get with the customer to get consent, please give them the updated forms.
Okay. Stephen, I hope we have responded well to your question.
Yes, it's clear. Thank you.
Okay, Karibu. Thank you. There's a comment there from James Mutia. You'd like a data protection policy. We'll get in touch with you. Thank you so much. And thank you, Justice Sudi, for... Thanks, Tom and CCI team. Okay, Karibu. Thank you, Justice. Okay, do we have any other question in the next 1 minute? There's a question from Kennedy. Please confirm that the information in consideration by the DPA is that which can be used to personally identify an individual.
Yes, thanks, Nancy. Again, the risk of sounding like a broken record, the law is very clear. Okay, the law says it's in relation to personal data. So we mentioned that if you don't want the law to apply to personal data that you have collected, then make efforts to anonymize, pseudomize, or randomize that information so that in case there's a breach, then it does not identify a data subject. Yeah, so it only relates to personal data.
Okay. Thank you, Tom and team, for your time. And thank you for the new knowledge that you've shared with us on that area. I think most of our eyes have been opened. We had heard about the new Data Protection Act, but we didn't have the details, and we really appreciate your time. So I'll say thank you so much from COP Consultancy. It was a pleasure having all of you here. Kindly go ahead and register for those who would like the notes, and share your email addresses. Also, before we close, we would like some feedback from you. There's a link we have shared with you. Kindly click on that link and give us feedback on the session and also on other other topics that you'd like us to discuss in the future. So let's give it a minute, everyone, each one of us, click on the link. Just 2 questions, and would really appreciate if you can respond to those. So thank you. Your responses are coming through. Kindly, let's do this quickly. Click on the link, respond to the questions. We really value your feedback, so kindly just go ahead and do that for us. We appreciate it. Thank you for the good comments that are coming through. We appreciate. Thank you, Adrian, Wilfred, Kennedy of Amref Sacco, asante. Adrian Odhiambo, asante sana. Thank you, Andrew and Athman. We appreciate your presence here. Thank you for the comment. Timothy, we'll get in touch. We've noted your email address. Asante, Peter. Okay, so thank you so much. We've received your feedback. We appreciate your time, and we look forward to another webinar coming soon. We will share with you information as it falls due. Asanteni, have a lovely day.
Thank you too. Good day.
Good day.
Thank you, Nancy. Good day.
Asanteni.